May it please the court, Your Honor, opposing counsel. Ladies and gentlemen, my name is Ryan Coy, and I represent the defendant, Mismo Fire Insurance. Desperate times call for desperate measures. And in this trial, you will hear of the plaintiff's desperation. Let me tell you the story about this case. On November 16, 2011, the plaintiff experienced a devastating fire, destroying the building and killing one, Mr. George Avery. In the 2 years before the fire, the plaintiff was suffering losses of over $1 million. And just a few months before the fire, the plaintiff's president, Mr. Jackson, informed the company's bookkeeper that if the plaintiff did not pick up new business in the last part of that year, the plaintiff would go under. Then, just 2 months later, the plaintiff hired Mr. George Avery, paid him $5,000, and gave him a key to the building. All of this during Mr. Avery's first visit with Mr. Jackson, just within a few hours. Then shortly after hiring George Avery, Mr. Jackson called the defendant and increased the plaintiff's fire insurance coverage by over $500,000. Therefore, Mr. Jackson was also increasing costs to an already struggling business. Additionally, the plaintiff had a $400,000 loan payment due to First Trust Bank just 12 days after that fire. Given the lack of new business and the losses that the plaintiff was already suffering, Mr. Jackson told the bank that the plaintiff was not in a position to make that loan payment. And the bank refused to refinance because Mr. Jackson did not give the bank any financial information or product designs to show that the plaintiff was creditworthy. Then, you will hear when the plaintiff was at its most desperate, just 12 days before that loan payment was due. The plaintiff's company experienced the devastating fire, destroying the building. On the night of the fire, at around 7 p.m., Mr. Jackson and Mr. Avery were the last two people seen in the building. And at the time of the fire, approximately 1 hour later, Mr. Avery was the only person left in the building. Additionally, you will hear that Mr. Avery was working late that night, but he had his own office and workspace on the 3rd floor of the Flinders plant. However, his body was found in the machine shop on the other side of the building, near the origin of the fire. Now you will hear that the NIDA Bureau of Fire Investigation has investigated George Avery in connection with 2 previous fires at Mr. Avery's 2 previous employers, Yafeng Company and Fast Meat Packing. At each of these companies, within his first 6 weeks of employment, both companies burned down. And in this case, you will hear that the plaintiff hired George Avery. And within his first 6 weeks of employment for the plaintiff's company burned down. This means that within a time span of 18 months, George Avery worked for 3 companies, and at all 3 companies, within his first 6 weeks of employment, all 3 burned down. Now the plaintiff brings this lawsuit against the defendant, attempting to get money for this fire. But the defendant is not liable under the fire insurance policy if the plaintiff started the fire. Therefore, you must determine whether the plaintiff or any of its agents deliberately caused the fire in this case. You must make that determination by a preponderance of the evidence, which means that you must decide whether it is more likely than not that the plaintiff or any of its agents deliberately caused the fire. Desperate times call for desperate measures. At the end of this trial, after you've heard all the facts and testimony, I will ask that you return a verdict in favor of the defendant as not liable. Thank you.